It doesn't matter what name you write in. People write in all kinds of names. They write themselves in, they write their neighbors in, they write their friends in, they write famous people in, they write celebrities in. Whoever you write in, unless that person filed a nomination paper with the election office 40 days before the election, that will not count. So I'm an election law attorney here in Phoenix, Arizona. I work for the law firm Ballard Spahr. I specialize in all things related to elections, from election administration to campaign finance to redistricting and everything in between. So when you write a name in on the ballot for a candidate, it may count. It depends on whether or not the person filed a nomination paper 40 days before the election. So in order to be counted, the person had to have nominated himself or herself to be a viable candidate for that election. If the candidate, if the person you write in did not nominate themselves and someone writes them in, then that will not count. It would be as if you did not vote at all. So those names will be posted at the polling place, and if you vote by mail, you can also get a list of those names on the election official's website, the Secretary of State's website or the county election officer's website. It depends. So when someone writes a person's name in, then when that ballot gets tabulated, the machine's going to spit that ballot out so that the election officials themselves can look at what's been written in and determine whether or not that person was properly nominated and whether that should count. So it's ultimately going to be up to the election officials to determine whether the proper name was written in. And that's going to, in some instances, be a judgment call. And if, for example, you say Joe instead of Joseph, and the election official doesn't count that ballot, then that would ultimately be a question for a judge to decide if there's a close election, and it hinges on whether or not that name was properly written in, and the court's going to apply what they call an intent of the voter standard. In other words, what did the voter intend? And if the court can determine that the voter intended to vote for me, whether it's Joe or Joseph, then they're going to count that ballot. So the question is whether anyone has ever successfully written in Arizona and achieved a place on the ballot. And that actually did happen a few years ago when former House member and state senator Don Shooter ran in his primary election as a write-in candidate, and enough people wrote him in so that he could get his name on the general election ballot, and he eventually won. And something to say about that is just, even if you nominate yourself as a write-in candidate so people can vote for you and your vote will count, the only way that you're going to get your name on the ballot is if enough people vote for you to get you on the ballot, and that number is the number of petition signatures you would have had to obtain if you ran through the petition process. So if someone qualified themselves to run in the primary election through the nomination petition process, but they ultimately lose the election, then they are not allowed to run as a write-in in the general election. That's called Arizona's sore loser law.